wait till 7:15.
So we got a couple minutes, but we gotta get Chris's attention.
All right.
Right?
Yep, thumbs up.
Okay. Good evening. Welcome to the Zoning Board of Appeals meeting for March 7th, 2018. Per the open meeting laws, this meeting is being audio and video recorded. Tonight at 7 o'clock, we'll have an appeal review for 144 Seekonk Street. The town has asked for a continuance for this because our expert peer reviewer, Patrick Gardner, cannot be with us due to the weather. So I would ask for a motion to continue that public hearing till April 4th at 7 o'clock. Mike?
I make a motion that we continue the public hearing for Edward O'Hart for an appeal of the building commissioner's zoning enforcement officer's decision and fines in accordance with Massachusetts General Laws, Chapter 48, Section 8, and the Norfolk zoning bylaws, Section D1, for the land clearing, excavation, filling, gravel removal, or clearing, cutting of trees prior to the issuance of all required approvals, permits, variances, and authorization on the property addressed as 144 Seekonk Street. Reference assesses map 23, block 76, lot 71, in the R3 zoning district.
Do I have a second? April 4th at 7 o'clock.
April 4th at 7 o'clock.
Any discussion? All those in favor?
Aye.
At 7:15, we'll be hearing 43 Rockwood Road, so we're going to take a 4-minute recess, and we'll continue the public hearing at 7:15 to hear 43 Rockwood Road, the appeal of the building commissioner's decision.
Yep, thumbs up.
We are back again to continue the Zoning Board of Appeals meeting of March 7th. At this time, we will continue the public hearing with regard to 43 Rockwood Road. Attorney Hilbert, would you like to speak, or?
Good evening, Mr. Chairman, members of the board. My name is Joanna Giorgio Hilvert from Mackey & Mackey at 1256 Washington Street in Norwood, and I'm here on behalf of the appellants Bruce and Marie Simpson. We appreciate the time that this board has spent in reviewing this matter. This is the fourth hearing on this matter, and we do recognize that this has been a diligent board that is making every attempt to get this right, and I commend you for that. We appreciate that. I would just really like to recap our position, which is that this nonconforming use has been extinguished and cannot continue for three separate and distinct reasons. And again, if this board agrees with me on any one, you don't have to agree with me on all three of these reasons, but if you agree with me on any one of these reasons, then this use cannot be continued. The first reason is because there was a change of a nonconforming use to a conforming use. And again, pursuant to your zoning bylaw section F2B, a nonconforming structure or use may be changed to be conforming, but once changed to be conforming, it shall not be made nonconforming again. And in 1972, when Mr. Richard Boomer purchased the property and converted the office building to a real estate accessory building. It had previously been a restaurant. When he converted it to an accessory real estate building, at that time, that was a conforming use in Norfolk by your zoning bylaw. He did obtain a special permit from the Zoning Board of Appeals for an extension of a nonconforming use. However, the board in its decision noted that this use is a lawfully as of right use. So we can't know why he got a special permit. I don't believe he needed to. It was a lawfully conforming use at the time. Thus, in 1972, the nonconformity was extinguished, and the use cannot be continued because of that. Second, between 1972 and today, there have been at least two periods where the building has not been used for any use, never mind the nonconforming use, for more than 2 years. And again, pursuant to your bylaw, section F3B, any non-agricultural, non-conforming use that has been discontinued for 2 years may not be renewed. I believe there's ample evidence in the record showing that this property was not used from a period of 2001 through 2011. And again from 2014 to the present. You do have an affidavit that the Simpsons previously submitted. You also have, in Attorney Mackey's original memorandum, you have a memorandum from this Zoning Board of Appeals dated April 27th, 2011, which states, it's from the Zoning Board of Appeals to Town Council, which states, the house has remained vacant and boarded up for the last 6 to 8 years. So while we may argue today about what happened 10, 15 years ago, in 2011, they were much closer. It was the current time, right? They were much closer to the time, and so that should carry more weight than anything that is said today, is the information that was supplied by the Zoning Board of Appeals currently at the time. And in 2011, they noted it had been abandoned. I do have 2 additional affidavits for the board from 2 additional neighbors, noting that it has been not used. Several copies of those. Thank you.
Thank you.
We can share.
I have extras. Do you want me to pass them around? Sure, I'll take them. I don't think I have a copy for everyone, but if
Share.
we can share.
You will share over here, that's okay.
Okay. You get this one. We're not having copies for everyone. Essentially, what these two affidavits say is that when Mr. Callahan, who was a previous owner, stopped using it, it was not used again after that time. The appellants have provided substantial evidence that the use was discontinued for more than 2 years. The owner of the building has not provided any evidence to that effect. And again, the courts have consistently found that the burden is on the owner of the building to provide evidence that the use was not discontinued or abandoned. And there has been no evidence or minimal evidence provided by the owner of the building. And then finally, regardless of what your decision is on the nonconforming use, clearly the special permit has lapsed. So if nothing else, the building owner would require another special permit from this board to continue a nonconforming use. We can argue about, there was a discussion last time, which I think is what led to this being continued, as to whether or not the lapse of the permit resulted in the nonconformity lapsing. We can argue that point, and frankly, I don't think it's necessary because, number one, we have two other clear arguments for why this nonconforming use should be extinguished. And number three, in any event, no matter what the argument is absolutely clear that the building has not been used for more than a year. And under your bylaw, section G4, any use permitted by special permit that is discontinued for a period of 1 year or more shall cause the special permit to lapse. So I think it's uncontrovertible that the special permit has lapsed, so at the very least another special permit would need to be applied for. But I believe because of the other two arguments that we've presented, that should not be allowed by this board. So that concludes my presentation. If you have any questions, I'd be happy to answer them.
Any questions from the board?
Just wanted to double check, when did Callahan stop using the building, and when did the next one come in? Chris Grasso, I guess it was. Like,
Can
what
I-
would yeah.
Chris,
Yeah, like the Prudential was there for a while, right? He stopped
John
using-
John Cahalan was there, and he moved to the Wayside Building in 2001, and the property was not used. Dickie Boomer offered the property for us to purchase at that time. No one was in the house, and no one was in the little building. And then the property was sold to Kevin O'Laughlin in 2007.
And then I was going to ask Chris, when did the Green Trees asphalt, when did that
Green-
occupy the building?
Oh, Green Trees was there in March. No, they applied in March. They moved in about April or May of 2011, and they left in March of 2014.
Thank you. Thank you.
I just have a quick question, too. So my question is, it seems to me that the whole issue here is whether or not there was some discontinued use on this property. That's the entire issue. And what I'm wondering is, does anybody dispute that? Does the landowner contend that this property was in continual use all the way through from way back when it was a restaurant?
So first of all, I don't think that's the only issue, because the other question is whether the non-conforming use became a conforming use, and thus the non-conformity went away. That's an important issue. I think that's very clear.
But if the use was discontinued for 2 or more years, is it irrelevant as to whether or not it was conforming or non-conforming?
They're two separate and distinct arguments.
Okay.
Each argument becomes irrelevant if the other argument is true, essentially. But yes, if the use was discontinued for any point for 2 or more years, it is absolutely extinguished.
It doesn't matter whether it's conforming or non-conforming?
Well, if it's conforming, no, it would be allowed, because it's a conforming use. So, but once it becomes conforming, it cannot go back to non-conforming.
Okay. Okay. So then the issue then defaults then to, if it is a conforming use, was there a lapse for a year or more?
No, if it's conforming, that ends the discussion. If it ever became a conforming use, the discussion ends, because once it becomes a conforming use, even for a day, you cannot go back to a non-conforming use if it's conforming.
So if it's a conforming use, and it stops being used as a conforming use, then what rights does the landowner have?
They can do anything that's conforming to the bylaw,
They can do anything that's conforming to the bylaw.
or they can seek a special permit or a variance.
But if I'm not mistaken, Attorney, that would be predicated on the fact that as a conforming use is an accessory to the home. And since the
Correct.
home was abandoned, the conforming use goes away. Because a conforming use would be as a real estate, which was allowed by our bylaws as an accessory to the property. But once the house became abandoned, the conforming use goes away. Once
Okay.
it ceases to operate,
Okay.
which it did. I think the house has been empty for,
Over 20 years.
yeah.
In addition, once it is vacated, the town does not allow in that zone an office in a residential district. That's a residential district. If it was in
When-
your
when you-
back,
you-
your
When you
ne-
say, once it is vacated, do you mean the office building or the house or both?
either or both.
Either or?
The use, once the use is ended, then it can't go back to that non-conforming use.
What you have to do then is comply with zoning.
Bruce, we'll probably let public comment after we hear from both
Okay.
attorneys. I want to give,
Okay.
any other questions from the board?
All set.
Okay. Amy, Bob Bullock, I think, was invited. Did he contact you at all, or with regard to coming, or?
No, it was my understanding.
Okay, all right. Attorney Nanaselli?
Good evening. Thank you again, Attorney Thomas Nanaselli for the landowner, James LaRusso. I've stated my position previously. I can answer any questions and summarize my argument if you wish. The only thing I would say is that I really don't understand counsel's characterization of the 1972 permit. I have a copy of it in front of me, and it clearly says that the applicant, in that case Mr. Boomer, was seeking a special permit to change an existing non-conforming use into another non-conforming use. The request is to change the present restaurant into an office building. The law states that by special permit, any non-conforming use may be changed to another non-conforming specified use, not substantially different in character nor more detrimental or objectionable to a neighborhood. This issue of the issue of the accessory use, I think, is a red herring. This was a non-conforming use when zoning was enacted in Norfolk. By the way, I did find another plan showing this building dating from 1944, which I can share with you if you'd like to see it. It was non-conforming up until 1972, and when the special permit was issued authorizing another non-conforming use. It never lost its non-conformity. That's been my argument from day one. It never was an accessory to a residential use. My client purchased the property in 2007 from Mr. O'Laughlin, and he's used it since that time. What happened prior to that time, we can't pin down with any accuracy. All I can say is that under three different sections of the zoning bylaw, the Zoning Enabling Act, rather, Chapter 40A, there are requirements that, or prohibitions against the zoning enforcement agency taking any action against uses that may have been in violation at one point in time, but either there's a 6-year period, there's a 10-year period. If those time limits go by, there's no enforcement action that can be maintained, or at least none that would stand up in a court of law. So basically, that's my argument. I'll summarize the rest of it if you want me to, but I just wanted to comment on counsel's interpretation of that special permit decision in 1972. And Mr. LaRusso is here again. He has his check register to show that he was collecting rents there since, well, up until May of 2016. And actually, he's still using the property. After that period of time, he had it rented, he had it listed for rent, and he had several prospective tenants. A couple of them actually met with the building inspector. So he was actively trying to rent this property until the Simpsons filed their complaint. And at that time, I instructed him to tell the broker to take it off the market. But he hasn't abandoned it or discontinued his use, I should say, not abandoned. He hasn't discontinued his use. And the issue of the 1 year statute, the 1 year special permit requirement was addressed, or I tried to address it by, excuse me 1 second. By handing out copies of that case I discussed, Bartlett versus the Board of Appeals of Lakeville, and any zoning bylaw that attempts to stop a non-conforming use less than 2 years, within less than 2 years, is in violation of Section 6 of Chapter 40A. That's the holding of this case. And this, like I said before at the last meeting, this case was adopted, or the holding in it was adopted by our Supreme Judicial Court. This was an appeals court decision. So basically that, unless you have any questions, that's my argument.
Done.
Yeah, I'm sorry, Attorney,
Nanaselli, Tom Nanaselli.
I'm going to say Attorney Tom, okay?
That's fine, yep.
So, I think that I heard that you said that this went from one non-conforming use to another non-conforming use.
Correct.
Per Mr. Boomer's application here to the zoning board in whatever year that was.
1972.
Then, I think I heard, and I'm not sure, an argument that said that even though the property may have been vacant for a period of time, that the fact that it wasn't enforced and then it then became a usable building under the non-conforming use that was provided it in 1972, that kind of negated that period when the building was vacant, which would have been between 2002 and 2008?
Well, that's in dispute. I don't agree that it was vacant necessarily between those 2 years. It was vacant at some point.
I didn't
but-
say 2 years now, okay? I'm not talking about
Okay.
the recent period. I'm going back when we know that Mr. Cahalan moved out of the property until such time as around 2008, when possibly somebody else went in, okay?
Mr. LaRusso bought in 2007 from
Okay.
Mr. O'Loughlin.
Mr. O'Loughlin, okay? Well,
Right.
for-
Basically, O'Loughlin flipped the property.
So sometime between 2002 and 2007, then, we do have information that says that building was vacant. And I'm trying to understand if you are presenting an argument that, in effect, nullifies the zoning law that says it can't be vacant for a period of more than 2 years back in the period of 2002 to 2007.
I'm not saying that it nullifies that. What I'm saying is that what happened between 2002 and 2007 is so far ago that, so long ago, that it would be inequitable to enforce this against the present owner who bought the property in 2007. This is called, there's a legal term called laches, which is an equitable doctrine, which says that basically if someone has a claim and they do nothing to enforce that claim, or if they have a legal right and they don't enforce the right to the detriment of another person, after a certain period of time, they are barred from exercising that claim if it's an unreasonable period of time. The Simpsons have been living in that house for 25 years at least, I think, probably more, 40 years.
I'm older than dirt.
So clearly, they knew what was going on. And if they felt that it had been abandoned or if it was no longer being used for any purpose for a period of 2 years or more, or even 1 year, Mrs. Simpson certainly knows what to do. She did it here. She filed the complaint or the request for enforcement to the building inspector. So, in my opinion, she sat on her rights. If this went to court, I would bring up a defense of latches, because she sat on her rights when she could have enforced the zoning bylaw, assuming she was able to prove her case. Now she's coming back. I don't want to say she. That Simpsons are coming back 10 years after my. No, what am I talking about? Yeah, 11 years after my client bought the property, and they're trying to shut his use of that property down. It's not equitable. Regardless if it was vacant for 1 year or 2 years prior to the time that he bought it. That's 11 years ago, minimum.
So Tom, your argument is one of an equitable argument. That's what is that your argument in this? I mean, you reference Bartlett here. I'm not 100% sure what Bartlett does for this case.
Well, because I brought up that Bartlett case because under the special permit section of the zoning bylaw. Let me just pull it out. So,
Okay.
Excuse me.
It's Section G4. What I think he's referring to, Bob, is our Section G4 says if a property isn't used for a period of 1 year that has a special permit, that special permit expires. So what Attorney Nanicelli was saying is that the Superior Court ruled that you could not use the 1-year rule with regard to a special permit. It had to be a minimum of at least 2 years. Is that correct?
You cannot have a provision that would eliminate a non-conforming use unless it was non-conforming, unless abandonment of a non-conforming use, unless it was, I shouldn't say abandonment, discontinued for 2 years or more, okay? And that provision of of your bylaw, I think, is in violation of this holding of this was the appeals court, and upheld by the Supreme Judicial Court, or adopted by the Supreme Judicial Court. And the other thing is that 1-year provision is under your, in my estimation, comes under Section 9 of Chapter 48, the special permit section. I gave you copies of both Section 6 and Section 9. And the special permit that we're discussing now, that's in your bylaw, talks about issuance of a special permit, not the type of special permit that was issued in this case, to continue a non-conforming use. So even if it doesn't violate the statute because it only applies to that type of a special permit, it certainly can't be used to enforce a shutting down of a non-conforming use that's been in existence less than 2 years, or a discontinuance of the non-conforming use, I should say.
Can I, I'm sorry, I just want to.
Go ahead, yes, Bob.
Yeah, so, and again, so you're, all right. So, Tom, if there was a period of time where this building was not being used, are you suggesting that you can assert the doctrine of latches to benefit your client? And then, and the other question I kind of associate with that is, what is the definition of non-use? So does it mean that no, in other words, suppose somebody was storing files in there for 10 years, is that a use?
It is.
Is it not a use? I don't.
No, it is a use.
You know, so I don't know what use means.
And that's why I said that, I'm sorry to interrupt you, go ahead.
No, go right ahead, Tom.
So that's why I said Mr. LaRusso, even after his tenants moved out, was still using the property, if you want to.
And what about the prior owners? Was there a period, there was different, prior to Mr. LaRusso's ownership, who owned the property?
O'Laughlin was a developer. He bought the property in 2007, flipped it after 2 months to Mr. LaRusso.
Then prior to Mr. O'Laughlin, who owned it?
It was Richard Boomer,
Oh,
right?
Boomer owned it, okay.
I believe it was Richard Boomer. Yeah. I don't think there was anybody in between there.
Okay, so I'm trying to determine, how do we know that it wasn't used? And then if it wasn't used, then the question is your defense or so forth, is latches, that's what's going on here.
Well, I mean, first of all, the evidence that it was not used is, in my estimation, speculative for more than 2 years. Over and above that, let's assume that that's true. Sometime before 2007, there was a continuous 2-year period when it wasn't used for anything. Okay? I don't think that it would be equitable for this board now, since the Simpsons had plenty of time to bring that issue before you during that time span, to come in 11 years later with a new owner, relatively new owner, who has used it since 2007, and try and enforce their rights now to his detriment. That's the definition of latches.
Okay.
Excuse me, maybe I'm a little unclear here, but although the Simpsons are the plaintiffs to the issue of the enforcement of our zoning officer, correct? The fact that the Simpsons didn't bring it to the attention of the zoning officer until what date, what time?
2017.
2017, versus the zoning officer taking action in 2005, 6, 7, 4, whenever 2 years passed. I'm having trouble understanding the difference, because our responsibility is not to the plaintiff in this case, if I understand this correctly. Our responsibility is to our zoning officer, our employee, who is enforcing our zoning laws. And so my question as it relates to the defense of latches, which the essential element of latches is an unreasonable delay by the plaintiff in bringing the claim, because latches is an equitable defense. It is ordinarily applied only to claims for equitable relief, such as injunctions, and not claims for legal relief. I guess I don't understand how that has any element of propriety here, because it's really when our zoning officer determined in his own right that there was an issue.
Well,
So am I making sense here?
Yeah, that makes
Yes.
perfect sense.
All right.
well, Mr. Bullock, if you read his, this was let's go from the beginning. Mr. and Mrs. Simpson filed a request for enforcement of zoning bylaws. Mr. Bullock said there was no violation. He said the property had been in use for at least 16 years and for as long as he had been building commissioner in Norfolk. All right. So I'm actually, this case should have been defended by the building commissioner and town council. I stepped in and picked up the laboring oar because it's my client's property. That definition of latches that you read, although it's an equitable defense, the part that you read about it's only being applicable to equity cases is is not accurate. You can bring a defense of latches in any type of lawsuit that is brought in Massachusetts. now. And the question is, does it apply? And will the court apply that defense or listen to that defense? So I don't know. You have Mr. Bullock's decision. I don't know how town council weighed in on this, if at all. If he did, I'd like to know what he had to say.
Town council did weigh in. He met with Mike and I briefly, and town council felt that this was an issue of fact. Was this building used continuously from 2016? And he said it's really the zoning board of appeals job.
I'm sorry, from 2016?
2002 on.
2002.
Correct. It is the board's, he said it's the board's role and job to determine, based on the facts, whether there was continued use. And if there wasn't continued use, then the appeal would be upheld. If there was continued use, it would not. But as he said, it's clearly a very good case for zoning boards of appeals to look at the facts. What are the facts surrounding non-conforming use and/or special permit?
So why did you choose 2002?
Because that's when Mr. Cahalan left the building, and we have documents from the zoning board of appeals stating that this building was vacant for 5 to 7 years prior to when the pavement company applied for a special permit and then withdrew it.
You had documentation from this board?
Yes, I think it was presented at the last meeting.
Thank you.
I think I put an asterisk next to it.
Yeah, thanks. I did see this. This is a memo from your administrative assistant at the time for the ZBA at this board, and I don't consider this evidence. Basically, what she's saying is that Mr. Boomer sold the property to a developer, which we know, who in turn sold the property to my client, who's not a developer. The house has remained vacant and boarded up for the last 6 to 8 years. Well, he moved in 2007. Not moved in, but he occupied it in 2007. So I don't, this is from your administrative assistant. I don't consider this evidence. I just don't. I'm sorry. Cool.
I had one follow-up question for you,
Sure.
just going back to the laches defense that you've been raising,
Yes.
and the back and forth that you were having there. Clearly, I think some of us on the board may have a different interpretation of it than what you're presenting here, so you're arguing that the definition that was read is no longer completely accurate in its application
Right.
in the Commonwealth. You came with some example case law supporting one of your other arguments. Can you provide case law or a citation to a ZBA decision that enforces laches in the way that you're...
A ZBA decision, I'm not aware of any. I could search for it, but I'm not aware of any. I don't have any with me right now.
And would your argument be if ownership hadn't changed hands, that laches still applies? Because you seem to be arguing it's extra inequitable, for lack of a better term.
It's detrimental to the present owner.
No,
correct.
because ownership changed. So if the same owner owned it and
And it
they
would-
had tried to work, you would disagree with that. All right. So it's not the time frame, it's the ownership change.
Correct.
But isn't part of the definition
An
of
ownership-
laches the time frame?
It's an unreasonable delay, and I consider waiting 11 years after my client bought it unreasonable.
Right, but if ownership had never changed, you just said that you didn't think laches would apply.
It may not apply if it's not unreasonable.
So then the time frame wouldn't be unreasonable. Do you see the, okay, good. Do you see the question I'm trying to get at here? Is it the change in ownership that makes it inequitable, or is it the time frame, which is an underpinning of
It
laches?
makes it inequitable to my client, yes, because he's owned it for 11 years, and there was plenty of opportunity prior to him owning it against the prior owners to bring this type of a request for enforcement of the zoning bylaws.
In your opinion, in your client's opinion, that's where the inequity lies?
Yes, because it's to his detriment now. You can't say that if, let's assume Mr. Boomer owned it until 2007, and then he wanted to do something with it. He couldn't come in and say, well, you know, even though it was boarded up for 2002 to 2004 or whatever, he couldn't say that he couldn't tell you that it's not equitable for you to shut me down now. And I would say that it would be, because he still owns it, and it's not detrimental to anybody except him, and he's the one who let it lapse for 2 years.
Moving on from the laches defense, what's the use that you allege is occurring right now? It's what?
My client has rented it until May of 2016. Since that time, he's changed the plumbing. He's had new bathrooms installed. He's painted it. He's done other cosmetic improvements inside the building to get it ready to rent. And he's marketed it up until the time that the Simpsons filed their request for enforcement. And at that time, he told the broker not to market it anymore based on my instructions. But he's had several tenants who've talked to him about renting the property. He even had one person who wanted to buy it and move his business to it. And that person went down to speak to Mr. Bullock on a couple of occasions. So he's actively trying to rent it. And I don't consider that non-use.
Mr. Chairman, Attorney Nanicelli.
Yes.
With hindsight, do you think your client should have done a little more research before he bought the property regarding our bylaws, what the building could be used for, couldn't be used for? Do you think with hindsight that perhaps that would have been a smart move?
I represented him on the sale transaction. I didn't represent him as far as looking at the zoning bylaws or anything like that. I believe he did speak with Mr. Bullock before he bought the property. Yeah. Do you want to?
Yes, I talked to Mr. Bullock. He informed me about the 2-year vacancy, whatever you want to call it. And there was a couple of things I wanted to do there. Said that weren't allowed. It had to be for office use only. So as far as I knew, I was all set. I understood the 2-year vacancy rule. I understood the house, there was nobody in it, had been abandoned. It was going to have to come down sometime in the future. And that's it.
Can I, sorry, just for clarification, we've probably
Yes.
hit on this, but what is the time period that everybody's alleging that this was not in use or abandoned or whatever the term is to suggest that this property wasn't being used? What is the time, when are we talking?
Well, I think the proof has to be, when was it being used, not when was it not being used. We know that in 2002, the building was empty when Mr. Kalin left. What we're trying to understand, and I think what we talked about the last meeting, was you providing evidence from 2002 forward as to the continued use of the property. And I think I mentioned that a check register, I would consider this legal document much greater evidence than a check register. So I think I asked you at the last meeting, could you provide canceled checks? Could you provide electricity bills, oil delivery bills if that property is on oil? Those were the type of things we were looking for as evidence that the property was continued to be used.
Okay.
Anything to prove. And on that
Other than my
notion,
client's testimony, so are you saying that you didn't believe Mr. LaRusso when he testified that?
I think I said that a check register to me was not proof, because anybody can fill in whatever they want on a check register. You would have to have a canceled check to prove that a check register made any sense. And I think in court, a check register would not hold up, whereas a canceled check would.
Well.
But that will be for our deliberation. If you have anything, do you have any more to add, or does the board have any more questions?
As far as getting a canceled check, how would he get the canceled checks?
We had this discussion too, is banks can give you either copies of your checks, you can request them. There's many ways to get canceled checks.
Going back that far?
Absolutely.
No. I don't know.
I can't get copies of checks from my tenants or past tenants through the bank.
Excuse me?
I can't get copies of checks, rent checks, from tenants or past tenants from the bank. They wouldn't give me anything like that, because those aren't my accounts.
You must have a depository showing your deposits into your checking accounts for this property.
I have a deposit, right.
And
but
did you
I
bring
didn't-
those with you as evidence?
I don't list them per each tenant. I do that in my register.
Okay, how about electricity bills, oil bills?
Again, I'd have to go and get these people to produce those things.
They were paying the
Green trees.
utilities.
They paid all the utilities.
Again, we are looking for evidence. We're looking for evidence. We need evidence.
You want evidence from the time that Mr. LaRusso owned the building? Is that
We're
what you're
asking
saying?
for evidence from the time of, I think we asked at the last meeting for evidence from the time of 2002 forward, whatever that period of time is.
Well,
I can't do anything from 2002.
he didn't buy it till 2007, so, I can ask Mr. LaRusso and talk with him and help him with this if you really want some evidence that.
I'm inclined to let the board decide if we want it. I mean, this has gone on, I think Attorney Hilford mentioned it, 4 hearings. I think at the last hearing, I made it pretty clear that evidence was to be provided.
We talked about the check register
We
last
said
meeting.
evidence. I think if you look back at the record, it said evidence. So I think we've gone long enough, as far as my opinion. I'll let the board make that determination.
Okay, so, I just need to clarify this. Are you saying that you're not, based on that check register, you're saying that it could be false and that my client may be falsifying it? I mean, is that what you're saying? Because he showed the individual rents on that check register. He doesn't, when he made the deposit, it was all the rents together. Together being, he owns maybe I should have explained this. He owns a building in Rentham Center. He has several tenants in that building. And he took all of those rents. They all went through that one checkbook. And he took all of those rents and deposited them all at once, probably near the first of the month if he got paid on time. So that's the issue with that. But he on the check register, that's the only evidence that we have of who paid what and how much each month. Would you like to see it again? He has it with him.
Does he want to submit it as evidence?
Like I said the last time, I think the secretary said what you can do is make copies of those pages. Just block out the stuff that I didn't want you to see, all my other tenants and what they're paying. So I want to give you something that's, listed like everything I do.
Well, we can submit this, but I think we should show the board the original check register that we showed them before. They saw it before.
I
So,
don't think he wants to see it. I've said that, right?
No, if you want to provide your check register as evidence, we'll certainly accept your check register as evidence.
you don't want to leave it here? Okay. Mr. LaRusso doesn't want to leave it here. These,
We had the same discussion at the last meeting, just to make you aware of that. We did have the same discussion, okay?
what discussion?
Discussion with regard to the check register.
I understand. Now, what he's done, he's copied, did you make copies of all the pages?
No, just the last 2 months.
Okay. All right, well, these are copies of the check register for the last 2 months, April and May, before his tenants moved out. And it shows the rent
I'm
that
sorry,
they paid.
Clarify, April and May of what year?
2016,
2016.
correct. So it does show the rents that his tenants paid for those months. If you, I'll submit these as evidence if you want to take them.
Any other questions from the board? Attorney Hilbert, any other comments? You don't have to.
address a few comments. I would first just like to mention that I completely agree with town council that this board's objective is a factual inquiry, and so a defense of laches is something that should be brought in court. If this board were to decide in our favor and the owner disagreed, he could certainly bring that to court. However, to come to a board like this and make a legal argument without any case law, I don't believe is appropriate in hand. In terms of the evidence, the letter to the from the zoning board to the town council, that is a memo from the zoning board on the zoning board's letterhead. The zoning board of appeals is the first line, and then it's the secretary, and finally, it's part of the public record. So I do believe that's absolutely can be used as evidence. Otherwise, it wouldn't have been submitted into the public record. I think it's absolutely clear that regardless of anything else we've discussed, there are, whether you want to say 2001 to 2011 or shorten it to 2002 to 2007, it's absolutely clear that that period of time the building was not being used. And Attorney Nanicelli said what happened prior to 2007 we can't pin down with any accuracy. Yes, we can. We have several people who were living there at the time who have submitted affidavits, and we have a memorandum from the Zoning Board of Appeals. So we have several pieces of information that do actually pin down what happened from 2000, let's just say 2002 to 2007, just to be generous. I would also like to say that Mr. Hanson, you're correct. This is it is the building inspector's, the zoning enforcement officer's obligation to enforce zoning, not the Simpsons. So if there were any argument, it would be against the zoning enforcement officer. And I do believe that there is case law that says you cannot bring the town has the right to enforce its bylaws at any time. As far as equity, if we're going to make an equity argument, I think that the citizens of this town have a right to have the bylaws enforced, and the abutters who bought property in a residential district have the right to have the bylaws enforced in that district, and I think that's the clear equity of the case. I would also like to mention that Mrs. Simpson did bring this up with the building inspector more than once prior to this time, so to the extent that's relevant. Thank you.
I'd like to open up to the public if they have any comments. Mr. Anderson?
Yes, my name is Bob Anderson, and I've lived at 37 Rockwood Road since 1976. In that time period, I've seen many people come and go, but not in the last 7, 8 years at the old Boomer Real Estate office. I will make note that I noticed many errors in Mr. Nanicelli's testimony. For example, Mr. Nanicelli did not mention how Kevin O'Laughlin, for approximately a year, had a sign on that property, Colonial House to Build. It was 4x4, red and white. When I asked Kevin O'Laughlin what his intention was, I had met Kevin at Linda's Variety in the center of town. He said it was to build a new house there and take down the old real estate office. I knew Jack Cahalan very well, and I knew Dick Boomer very well. And I also met Dick Boomer and Jack Cahalan after they left, and they both said that the place was vacant, that there was nobody coming in. Furthermore, I have not seen anybody. I have never met Mr. LaRusso until this night. I've never seen him there. I come and go many times during the course of a day, and the place has been vacant for the last several years and many years before that. I find it very hard that Mr. Nanicelli asks us to take into consideration Mr. LaRusso's check register, who has many business interests and who could submit checks from those other businesses and call them tenants. All right? Normally, in something like this, it comes down to a matter of certified copies of those issues or those facts entered into evidence. All right? Thank you very much. Oh, one final thing. There is a blind spot at that very corner. You have an overriding interest in checking out that corner for the school bus traffic that comes and goes. This is a residential zone. The school buses go to the Freeman School and the H. Olive Day School. I invite any of you who want to see that dead spot, come to my driveway, and you'll see it for yourselves. I noticed there's been a number of accidents there at that intersection, Boardman and Rockwood Road, over the years, and the most recent was this past winter. Thank you.
Thank you, Mr. Anderson. Any other comments from the public? At this moment, Mr. Nasiselli, did you want to speak?
No.
Okay.
I'm all set.
At this moment, I'd like to entertain a motion to close the public hearing for the Marie and Bruce Simpson appeal.
I'd like to make a motion that we close the public hearing for an appeal of the building commissioner zoning enforcement officer's decision in accordance with the Massachusetts General Laws, Chapter 48, Section 8, for the property addressed at 43 Rockwood Road, reference Assessors Map 14, Block 49, Lot 7, in the R1 zoning district, as it pertains to the Marie and Bruce Simpson.
We have a second.
I'll second it.
Any discussion? All those in favor?
Aye.
Aye. Thank you very much. We'll probably deliberate this evening, depending on our schedule, and we thank you for your time.
Thank you for your time.
At this time, we continue with our public hearings. 60 River Road, we have a variance request. The applicant has asked that the Land Use Office look at this proposal and continue it till the April 4th meeting. So I wonder if I could get a motion to continue the public hearing for 60 River Road variance till April 4th at 7:15 PM.
I'd like to make a motion that we continue the public hearing regarding 60 River Road to
April 4th.
April 4th at 7:15 PM.
Correct.
At this location?
Second?
At this location?
Hmm?
What location?
At this location, yes.
Second.
At the land.
Second.
You have a second?
He just seconded.
I second.
Okay.
I just-
Any discussion?
I'm sorry, second.
Thank you. Any discussion? All those in favor?
Aye.
Okay. We have at 7:45, which are now at 8:10 PM, we have a special permit request for 113 North Street.
We need to open that one too.
Okay.
113 has not been opened.
Correct. Okay.
I'd like to make a motion that we open the public hearing for Dana B. Willard, trustee, at 7:45 PM for a special permit pursuant to MGL Chapter 48, Section 9, as amended, and Sections F3C and F4A of the Norfolk zoning bylaws to allow the extension of a nonconforming use and alteration or enlargement of an existing nonconforming structure. The property is located at 113 North Street, Assessors Map 20, Block 71, Lot 22, and is in the R3 zoning district.
Thank you very much, Mike. The applicant has asked us to continue this public hearing. There's some issues still surrounding it, regard to ownership. This is a trust. So I would entertain a motion to continue the public hearing for 113 North Street till April 4th at 7:30 PM.
I'd like to make a motion that we continue the public hearing for 113 North Street for a special permit to a date of April 4th and the time of
7:30.
7:30 PM.
Second.
Any discussion? All those in favor?
Aye.
Okay. Do we need to do anything under the new business, the minor modification? I don't think we do, or
We don't.
we don't need to. The new business that we just discussed was the village at Norfolk, which was 25 Rockwood Road. The applicant changed one of the drawings, the house drawings, for one of the units. It was peer-reviewed by Glenn and Beta Group and felt there was no substantial change. So it became an insignificant modification, which did not require board review and approval. So that was
Do you know
done.
what the change was?
It was just a couple of design changes on the house lot. The square footage changed slightly, and the basic design, the roof lines changed. And we had Glenn review it to make sure there wasn't anything substantial. Okay. At this time, would the board so inclined to deliberate 43 Rockwood Road?
Let's get this over with.
Okay. All right. As I mentioned, the town council was very clear that we should be very clear with our facts, because if this does get appealed, the facts are what the Superior Court will be looking at. Okay?
You want to start with findings of fact?
Yes.
The property in question is 43 Rockwood Road. It's an accessory building to a residence in the R1 district. Is that correct? Is R1? Can someone back me up on that? I believe it isn't.
Right here. Where's your 43 Rockwood?
It should be R1.
Map 14, Block 49, Lot 7.
R1 district,
R1
yes.
district, okay.
Yes.
The property consisted of two buildings, a 1,123 square foot building that has historically been used as a residence, a residential building, and a 1,740 square foot building that has historically and periodically been used as a restaurant and/or office. The
1972, a special permit was issued
right.
to convert the property to a less non-conforming use, a restaurant to a general office.
But just to also confirm that it retained its non-conforming status.
Correct,
Okay.
correct. Because it had continued use. The restaurant had continued to 1972, and then the real estate office started up right after
So
that.
it was a restaurant, it was a non-conforming use restaurant.
Correct.
1972. And then after 1972, it retained its non-conforming status and became a real estate office.
Correct.
Okay,
Okay?
yep. Also in 72, Richard Boomer sought and was awarded a special permit?
Correct, that's what we just said.
All
Okay.
the same, what
Yeah.
you just said.
All the
Yeah.
same, in that whole thing, it still remained a non-conforming use.
Correct.
My understanding, that it was a special permit permit issued in 1972 for it to become the real estate office. It had
Correct,
been-
to change it to a less non-conforming use.
But it had no special permit prior to that.
Did not have a special
It
permit,
just was
because
being used non-conformance.
being used non-conforming.
Okay, got it.
And again, because our bylaws, it was the restaurants were in business prior to the enactment of our bylaws.
Yeah, okay.
It was allowed, and that's why it was a non-conforming use.
Okay.
When our bylaws came into play, we designated what was conforming and what was non-conforming.
Okay,
This, because it existed prior to that, was non-conforming.
okay.
Sticking with the facts, we have on ZBA letterhead dated
April 27th,
April 27th,
2011.
2011, that the house has remained vacant and boarded up for the last 6 to 8 years. The non-conforming office building has also remained vacant, although owner has attached a real estate sign over the Prudential Page sign in front of the property for the last year. So we've got documentation on ZBA letterhead that the building was vacant for a period of time greater than 2 years.
Can we wrap dates around that?
We can wrap the first date, which is 2002.
2001.
Okay. Whether or not we can wrap the second date, because the email states 6 to 8 years, and it also states that there was attached real estate sign at the front of the property for the last year.
And again, not to keep beating this thing, but
But let me just finish, but I think what's important is Mike's comment in the findings of fact was for a period of a minimum of 2 years.
Correct.
Certainly,
and just for clarification, so did Boomer operated in that spot as a non-conforming use up until 2002?
Yes.
In 2002.
Who
Oh,
rented
okay.
it to John
Yeah,
Cohalan.
right.
Got it, okay.
Yes.
Boomer was a real estate agent as well.
Up until 2002, so that non-conforming use continued from way back when, through the restaurant, all the way to the real estate office to 2002.
Yes.
And the question becomes, post-2002, was there use, or was there non-use?
Correct.
And
Continued use.
And based on this letter, which is a fact, okay, or memorandum
Yep.
to town council from the zoning board of appeal, written by Betsy Fajul, dated April 27th of 2011, all right, that said that the house has remained vacant and boarded up for the last 6 to 8 years. The non-conforming office building has also remained vacant. Okay? Although the new property owner has attached a real estate sign over the Prudential Page sign at the front of his property for the last year.
Oh, okay, hold on, just 1 second right there, just so I have this straight in my mind. I'm with you on that, but here's what I want to know. So, in 2002, it ceased being Boomer's thing.
Yes.
Okay.
He owned it. He still owned it.
He still owned it. In 2007, Mr. LaRusso bought the building.
Correct.
Well, someone
Okay.
bought it before.
Oh, okay,
before me.
so at what point, so you're talking about 2011, you're talking about somebody putting a real estate sign over another real estate sign. When did that occur?
Well, based on this memo, okay, it says, again, to read it, it says that the new property owner has attached a real estate sign over the Prudential sign at the front of the property for the last year. So that's not definitive, but that's why it's important, I think, the way that Mike worded the finding of fact, because whether it's 3 years, 4 years, 5 years, as
Yeah.
long as it's 24 months and a day,
Right.
it's 2 years.
Okay.
So it's,
But I almost wish we had like this timeline on a board so I could see, you know what I'm saying? I look at things that way,
Hey, Bob, excuse me, Mr. Chairman, if we can get through the findings of fact, then we can debate
Okay,
these,
okay,
have our, when
Okay.
we deliberate.
All right.
And just, I'd like to
Sure.
just, try to get through the
Yep,
findings
good.
of fact.
All right.
And everyone else just jump in as well. We also have an affidavit of no use signed by Bruce and Marie Simpson.
We have 3 affidavits.
3 affidavits, that's one. The
We have
second
Bruce
affidavit
Simpson, we
is
have
from
Robert Anderson,
Robert Anderson.
we have a 3rd affidavit from a Lynn Boyce.
We have those affidavits. We also have the testimony of Mr. Anderson this evening, which I thought was very strong testimony. He's a resident at 37 Rockwood Road.
Right.
The last 7 to 8 years, there's been no one there. He made that very clear. And many years before that were his exact words. The last 7 to 8 years, there has been no one there, and many years before that as well. So we have three neighbors testifying there's been no activity there.
We have a check register from 2016 for 2 months for rent checks, I think they are. Is that? They
Which
appear to
I don't
be-
think they're very conclusive.
No, that they say rent, so we have 2 months in 2016 of rent checks. As the, Mr. Nanaselli's client's testimony in 2016. Any other findings of facts?
Let's see.
Covers the timeframe, and then it also covers the timeframe of his purchase.
Mr. Bullock,
Some bridges.
Building Commissioner Bullock testified that for the 16 years he's been building commissioner, he felt the building was in use.
Is that something that, did he verbally say that? Did he write that?
He wrote that in his,
Yeah,
his
so
in
there's a
the,
lot plan.
the appeal,
So there's
and he
some
stated it,
timeframe,
he stated it here.
according to
I
that.
wish we had an affidavit from Mr. Bullock, but we don't.
We do not.
we do have a letter here
But there's nothing to
from him
controvert it.
dated September 6th of 2017.
Okay, we'll enter that as evidence. What's that say, Don?
Received your letter hand dated, which you've asked for my determination regards to special permit. It was written to Bruce and Marie Simpson. This is based on the information I received as well as my personal knowledge of property. I find that this property lies in the R1 zoning district, has a dilapidated single-family house that hasn't been lived in for some 20-plus years. The structure that is the premise of the discussion has been maintained in the property for over 50 years. It was once a restaurant called the Tack Room. The Tack Room was a restaurant-type use up until 1972. In 72, Mr. Boomer received a special permit to change the restaurant type, to change the non-conforming use restaurant to a less non-conforming as an office use. It has remained an office use for approximately 45 years with different tenants, but the same use. Please note, special permit decision dated October 12, 1972, where it states the request is to change the present restaurant into an office building, which we have that information. What I understand from your letter is it's your opinion that this is to be only allowed as an accessory use, but it's my opinion that the property has been deemed non-conforming from when the restaurant was there and was issued a special permit to allow for a less non-conforming use to continue. If it was legal without the benefit of a special permit, when the board should have never issued the special permit for the change to a less non-conforming use back in 1972. The use has been maintained for the past 16 years, as long as I have been working for the town, and as far as I know, as long as 1972, when the special permit was issued.
I think we definitely should enter that as evidence. I don't think he
Yes.
provides any proof
No,
that it
but it
was
is evidence.
occupied. It's evidence, but there's no proof in that letter that it was used continuously.
Yes.
Let's see, what else do we need for findings? What did the, Mr. LaRusso give us? The register?
Just gave us the register and his,
um,
and Mr. LaRusso only spoke to the last 2 years.
Right.
I think he spoke to 2016, 2017. He did not speak of any time period prior to that.
Correct.
So his testimony referred to the last 2 years only,
And the register information was only
2 months in 2016.
16.
Should we enter anything that suggests that the defense is using factor of latches as a defense? It's a legal matter, okay?
I don't think it, and we have 2 attorneys on the board. I don't think it plays any, has any weight for the zoning board. It may have weight in a court of law.
Well, again, it's not that I want to start deliberating at this point, but I'm wondering if we should enter it in as a fact, and then, as we deliberate, then we can determine whether or not that's a legal issue outside the purview of this board. So I don't know if it should be considered a fact or not, to be honest with you.
I have something here I want to bring up, but you want to get through the facts, so I'm not sure if it's a
Why
fact.
don't we finish the facts? It's
Yeah.
up to the chairman. on
So
whether
is
it's
this a fact, though? Do you think is that a fact that should be?
Why don't we say the fact was that Attorney Naselli brought up the doctrine of latches? How's that? That's the statement, that's the
I
fact.
think so.
Okay.
Yeah.
I think it
Yeah.
should be.
Yeah.
I think it should be
Okay.
noted, I do.
I guess the statement of fact was there was no enforcement by the zoning officer.
It's a good point.
I think we'll expand upon that. There was no enforcement by the zoning officer even after he was notified by the abutter, Mrs. Simpson, of this situation, as we heard in testimony from Mr. Simpson
And prior,
at the prior meeting.
Well, and there was no enforcement of any, no action by the zoning officer from 2002 on.
Correct,
So there's been no action whatsoever,
correct.
positive or negative.
Okay. No enforcement since 2002 by the zoning enforcement officer, even after, and Mrs. Simpson brought it to his attention that the building was no longer in use, and that was the zoning enforcement laws going to be initiated or upheld. Okay?
Isn't it the fact that there was another tenant in there? There was another tenant in this building at one time. I mean,
Yes.
Callahan was in there for a long time,
Yes.
but then there was a gap. But then after LaRusso purchased the property,
Right.
the Green Trees Asphalt Company, Chris
It
Grasso.
appeared, since they applied for a special permit and withdrew it in 2011,
Right.
we could say somewhere after 2011,
Yeah.
there was a tenant in there, till 2016.
Right.
Mr. Chairman, to the best of our ability, can we notate the time periods that we do know the building was occupied? We know when Mr. Boomer was in there, we know when Mr. Cahalan was in there. Should we indicate the dates that we know it was occupied?
I think
That
that's,
was-
I think that's a good idea.
I do too. I think it's a good,
Yeah.
yeah.
So we know from 1972 to 1992 to 2002.
2002.
there was real estate operations
So-
inside the building
Mhm.
by Boomer Real Estate and by Prime Properties, which was John Cahalan.
Yep.
Okay. We know that in sometime after 2011,
Well, we also know that in 2007, Mr. Luso bought the building,
okay,
so.
2007, we have the building was sold, purchased and sold twice. It was purchased by
Right,
Kevin O'Laughlin,
Right.
and then it was sold by him to
Should we affirmatively?
LaRusso in
Should we
2007.
affirmatively state what we know about the period between 2002 and 2007? In other words, do we know anything about any occupancy at that point? Or
We
do
don't.
we affirmatively
We have
state
no
that we do
evidence of
not know
occupancy.
anything?
There's no evidence of
No
occupancy.
occupancy.
Should we state that?
Yes, we have no evidence of occupancy,
Yes, good point.
of occupancy. From
Prior-
2002
Prior
to 2007.
prior to the purchase,
Well, 2002, 2007.
Yeah.
Which is substantiated by that memo,
Yes.
if you trace the
Yeah.
timeline backwards. And there's no evidence to the
Right.
contrary that would
We also,
indicate that was inaccurate.
we also do not have any proof of occupancy from 2007 to 2011.
With the exception of Mr. LaRusso has because Mr. LaRusso owned the property, right? He can testify. He's a person that's here in front of us. He can say, hey, I occupy the property, or I had a tenant occupy the property. However, prior to that point, there's nobody to say anything,
Say that
right?
again?
Right. So we don't know whether or not, in other words, Ms. LaRusso's testimony, I think, means something. So if he says that he rented that building from 2007 on, let's just pretend he says that, okay? Then that's, whether or not it's true is irrelevant. The point is that he said it, and that's a fact, okay? But prior to that, we're back to 2002, between 2002 and 2007, where we don't have anything, we have nothing.
Right.
So whereas between 2002 and 2007, we affirmatively state that we have nothing on that, from 2007 to now, Mr. LaRusso,
Well, from
as the owner of the
2000, from
property stated-
2007 to 2011, we also have no proof
That's right.
of occupancy. Mr. LaRusso rented this building in 2011 or 2012 to Chris Del Grasso.
is Mr. LaRusso suggesting that he did not rent it from 2007 to 2011?
He provided us no evidence that that building was
Did-
was
But
being
but
used.
did he state that he did lease it?
if I recall, there was discussion of, he said that he had moved some files and some other things in that building
Yeah.
for his own use. But he never stated that it was put into any type of rental situation,
Right.
nor did he substantiate it in any way.
Well,
And files in a building, if that was the case, think of what people would be doing with old buildings. I stuck my files in there, so therefore I
Hey, listen, I'm
continue
just saying,
use. It's use. So if there was no use as an office building, that's what the special permit was for.
okay.
Use. That's what
Of an
the-
office building.
That's what it was.
Not of a
use.
storage facility.
Not a storage facility. It was
Oh.
use. So if it was not being used, that,
See,
it doesn't.
I think that gets weak, Chris. And the reason I think that gets weak is if he's paying utilities, if he's heating it, has water running to it, paying taxes on it, he puts some files in there, whether he comes for 1 hour a week or 1 hour a month to use it as an office building, then it's an office building. I don't think we need to go there because we have a major gap that's more than 2 years.
2002 to 2007.
Yes.
Right.
It's someplace in there, it's longer than 24 months in a day. And I believe that in itself is what the substantive issue is. But once you start to get into what happened in 2007.
Or speculating what happened.
You're not speculating because
No,
we
we're
have
not
case.
we asked him to provide electric
Yeah,
bills, gas
yeah,
bills. He
we
didn't.
have case law in town. We have actually properties in town.
Didn't give us
where
any of
the
that
building
stuff.
commissioner has, and we will be hearing one the next couple of weeks, where properties have files in them. They have other items in them that would be consistent with the business that was there. And they are being considered not being active for a 2-year period.
We asked
We have
for
a
that.
case in town, we have a case in town a building down on Old Campbell Street owned by
Okay.
Kevin Roach,
Yep.
which was once a garage. It has never ceased to have vehicles in it.
Okay.
But
Okay,
the building
okay.
commissioner has issued a finding that that building has non-conforming use for a period of 2 years. So the argument that because you have files in a building, or because you step in a building once, does not hold weight. It has to show use. And use doesn't mean, because if that was the case, just think of the defense people could use with older buildings in town if they wanted to hold on to them, but wait it out.
I respectfully disagree, only because on a personal note, I had rental office space in Atlanta, Georgia, that I used 3 days out of 365. And we had to file I was working for a major corporation at the time, a Fortune 100 company, and we had to file documentation, but as far as they were concerned, that was in use. I went there 3 times.
We asked for proof of use.
Asked for proof.
And he never gave it to us. No electric bill, no gas bill, no light bill, nothing, no utilities. We did ask for proof,
Right.
and that's testimony that we
Well,
requested.
okay.
And it was not provided.
So let's just, all right, so a fact would be then, with respect to 2007 forward, the fact is that, correct me if I'm wrong here, but that Mr. LaRusso is alleging that he did use this property, alleging that he did, and that he also could not provide evidence of his use.
Yes. That
Okay.
would be- that would be-
Well, he provided evidence in 2016 of 2 months.
In going back to 2002 to 2007, we can also say, as a matter of fact, that Mr. Boomer owned that property, right? And there's nothing to suggest that it was being used for anything.
Correct.
Nobody has stood up and said, I used this property sometime between 2002 and 2007. We have nothing at all. At least Mr. LaRusso was saying, I used it. But there's absolutely nothing between 2002 and 2007, correct? I mean, this is,
Correct.
all right.
You know, the fact, though, that LaRusso got the property in 2007, right? He was able to purchase the property with the understanding that he had this non-conforming use available to him. I'm not sure where is the town liable to identify that that was no longer a non-conforming use available to him? Meaning, do we have to establish non-use after 2007? More so than we have to establish non-use before 2007? You know, meaning after versus, you know what I'm getting at? Meaning, he purchased the property in 2007 with the understanding that this non-conforming use was available to him.
Well, he emphatically stated that he talked to the commissioner, who said,
Right. What-
Correct me if I'm wrong,
He said that
he s-
today. He
yeah,
said that today. He
right.
spoke to Bob.
Right. But but we asked him to provide proof of that.
Right, but if we're hanging the non-use of the period before 2007,
Our bylaw says 2-year consistent. It doesn't have a statute of limitation on it.
You're not
Right, but
stopped
the-
from enforcing it, and it's his due diligence at the time of purchase to research
Right.
whatever he thinks he might be getting and consult an attorney and have them
right, but
research
if you go to the
use.
enforcement officer and the enforcement officer gives you the impression that, here you go. I'm a little concerned about not having something after 2007 to hang our hat on
Let
in
me
terms,
ask you this.
you know what I'm getting at, right?
If in 2007, Mr. LaRusso had opened up a realty office in that space, moved in and set up space as a realtor, and was an active realtor from 2007 right through to whenever we first got this
Appeal.
deal, okay? What would we do then?
We would do the same thing we're doing today, because there was a period of non-use for 2 years, which, according to our bylaws, not only lost its non-conforming use, it lost its special permit. It lost its special permit.
And you're referring to the time period between 2002 and 2007?
Yes.
Okay.
Make sense?
Yeah, I'm just trying to internalize, because there's so many ancillary things that occurred that, and remember, the special permit was for it was for a
Office building.
office building, or what did it say?
General office.
Did it say realty?
No, it said general office.
Because remember, let's see what that is. Because we kind of agreed that.
For office space only. was what the permit was for in 1972.
Okay.
And what the board at that time said, or implied, was since the new use is allowable by law, in other words, the new use is allowable under the zoning laws in 1972 as an accessory
As an
use to a
accessory
home.
to a home.
Correct.
For an office like a real estate
Wh- wh-
office.
Why
Real
did-
estate office.
But it's not.
But that's not what he asked for. He asked for
asked
office space.
General office
Correct.
space. Okay.
Correct. If we were all on the board, we would have caught that in 1972.
Of course.
Any other findings of facts? I think we sort of got into the deliberations already.
Little bit,
Kevin?
yeah. All right, do you want to, you want me to make a motion?
Okay.
Let's take a 2-minute, can we take a 2-minute recess?
Sure. Chris, could we take a 2-minute recess and come back?
Chris?
She's there, she's there.
Can we have a 2-minute recess? Thank you. She doesn't look happy about it. 2-minute recess?
You ever feel like you're in a I think it's going to be a good debate.
Welcome back to the zoning board deliberations for 43 Rockwood Road. Mr. Vice Chairman, you were going to make a motion?
Mr. Chairman, I would like to make a motion to grant the appeal of Bruce and Marie Simpson of the Building Commissioner's decision in accordance with Massachusetts General Laws, Chapter 40A, Section 8, for the property addressed as 43 Rockwood Road, reference assesses map 14, block 49, lot 7, in the R1 zoning district.
This is a motion to grant the appeal. So it require a full vote. The board? Mr. Vice Chairman?
Do you want to do any more discussion?
Any,
Discussion.
oh, you made the motion. Do we have a second to the motion?
I'll second the motion.
Okay, any discussion of the motion?
I'm concerned, I'm concerned.
Do we have to, at this point in the discussion, read in the fact?
Yeah, have
We've
we,
done the finding of facts, it's, time to vote.
have we
Should-
deliberated?
should
have we
we-
deliberated?
I mean, we can deliberate some more, yeah, absolutely, right?
We have a motion on the table.
And now's the time to discuss it.
Right.
You know what? Are we missing a story here? I mean, shouldn't a story be kind of told as to what we're thinking about? If we're going to vote on something, what are we thinking about it? I mean, I don't know what you're thinking. I don't know what you're thinking.
All right. For me, it's pretty clear, and it comes down to, has there been, and when we talked to town council, he said, you got to stick to the facts.
Okay.
And I heard a lot of facts that weighed heavily on the side of Bruce and Marie Simpson. I didn't hear a lot of facts that weighed heavily on Mr. LaRusso's side, unfortunately. So I'm dealing with the facts I heard. I've seen affidavits that the building wasn't used. I've heard Mr. Anderson testify the building wasn't used. There was a third resident that testified the building wasn't used. So from my perspective, and that's the crux of this whole issue for me, was it not used for a 2-year period of time or greater? There's no doubt in my mind that this building was not used for a 2-year period of time or longer. So all the other stuff is kind of tangential to the main argument and the what I think is the meat of this case.
All right.
But when it comes to the evidence we have on the side of what Bob Bullock has presented, we have his letter, right?
Yes.
We have no sworn affidavit from Mr. Bullock that, I mean, if he were here tonight, I would have said, Mr. Bullock, did you check the property once a month, once a year, once a week? How do you know it wasn't
We
used?
requested that he be here?
We requested that twice.
Right.
Yeah, so, I mean, we have,
Right.
those are the questions I would have asked him tonight.
Right.
Provide us some proof that you did, in fact,
Yeah.
visit the building. Did you go inside the building? How often did you visit it?
Okay.
I don't know. We don't know any of that.
But what was that one statement that we read before that he?
He said in his
he
16
says
years,
it-
he thinks the building's been occupied. I mean, we've got people that live right next to it who said it was not occupied.
So if I was to expound on what you said, and I agree with you, and if I was to expound on that, what I would say is that from the period between 2002 and 2007, I cannot see where anybody has alleged or shown or proven or anything that there was any use in that building.
Mr. Nanicelli even said, you know, we're not disputing the fact that it wasn't.
In his defense of Latches, although it may be a good defense, I don't think fits within the purview of this board. I think it is a legal issue, and I don't think that, and I think it's a good argument, you know, yet to be determined. But I think the bottom line is exactly what you said, Mike, is that, you know, I think that our decision-making kind of stops at whether or not we think that there was a 2-year period of non-use. And if anybody can tell me otherwise, it suggests to me that between 2002 and 2007, nobody can allege that it was being used.
And residents have a right to have the bylaws enforced.
Yeah.
This bylaw should have been enforced by the building commissioner a long time ago. I mean, but you're right. I think that the 2-year is for me, the crux of this whole issue.
Mr. LaRusso said that he knew about the 2-year thing
Yeah.
when he bought it. Do we have enough evidence to say that it was not being used between 2007 and 2011 when Chris Grasso came in, which is another 2-year period?
If
Is
you-
that
I'd
relevant?
like to
Is
see
it-
that, I'd like to set under his umbrella of owning it, if there's a 2-year period, we can count as evidence, that would be very helpful.
Well, on this, I don't think we need
I
more
don't
than
think
one 2-year
he
period.
didn't provide any evidence that it was being used,
Right, same.
other than his
our evidence
his
is
own
that-
personal use.
Right, so our evidence is that we don't know of any other tenant he's had in there using that building as an office prior to 2011 when Green Trees came in.
Correct.
And he's owned it since 2007.
Correct.
He says he knows he had the 2-year
Correct.
concern, but yet didn't apparently fill that gap with a function.
I mean, there's a bathroom on this property. If I'm not mistaken, state law says when you rent a property, you cannot charge your tenant for water. So he had to retain the water department bill. He could have presented us a water department bill
Right.
showing us use of a toilet.
Well,
We received no evidence.
Right.
So there was, you can use your check register as an argument, but there are other bills. The electric company, whether it be a triple net lease or not, will provide, under certified requirements, copies of electric bills. And we have none of that. We don't have any of that information at all
And
till
that's what I'm
today's
saying is-
date.
That's what I'm saying, it's important to me at least to understand that while he owned it, knowing that it had to be occupied to continue this non-conforming use, it apparently wasn't being used between 2007, 2011, which I think is a fact or an important.
There-
The attorney did make some reference to the fact that either he was planning on using it or was using it himself. But again, getting back to information from fact, is there was no fuel oil bill showing it was heated, no electric bills, water bills. There was nothing. Even if my original, the comment I made earlier about if he used it himself, whether or not that's an official use as an office, if it became his office, he didn't even provide to us any documentation to say that he used that office himself from
We gave him
2007
ample
to 2011.
opportunity to give us evidence. I think we bent over backwards to have him state his case and make his case. The chairman asked him at the last meeting to bring all that. They brought no additional information with them tonight. So, I think we've done everything we can to try to help them.
I think it's important that
Haven't
we
helped
just
themselves.
discuss what we discussed. I think that was important. Thank you.
Okay, so I still have a motion on the table. Do I have a second at the motion?
I second your argument.
Okay. Any further discussion? Mr. Vice Chairman?
Yes to grant?
Done?
Yes to grant?
Mr. Luciano?
Yes to grant?
Yes,
Bill.
Grant.
Devin?
Yes to grant.
You weren't
I
here
don't
for the
think I was
podcast,
here
so you
for such a
cannot.
public hearing.
And as chairman, yes to grant.
I was wondering which way you were going to vote.
Do I have a motion to close the, that ends our business for 43 Rockwood Road. Do I have a motion to close the zoning board of appeals meeting at 8:45 PM on the 7th of March?
Make a motion to close the hearing of March 7th, 2018 at 8:45.
A second?
Second.
All those in favor?
Aye.
Thank you very much. Good night.
All right.
Thank you, Chris.
Madeira, good job jumping in.
Great job.